Good afternoon, Larimer County, and welcome to our February 5th, 2024 afternoon land use hearing. I'll call this meeting to order at 3:01 p.m. And if you all would be kind enough to join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Again, thank you all for being here. We appreciate your participation. What I'd like to do is we'll introduce ourselves. We'll ask the community development folks to introduce themselves. We'll say a little bit about procedure protocol, and then I'll say a word or two about the consent agenda items, and then I'll go through a list of the 4 items that are before us this afternoon. My name is John Kafalis, Larimer County Commissioner from District 1. I'm joined by my commissioner colleagues, Kristen Stevens from District 2 and Jody Shattuck McNally from District 3. We also have Tessa from the Clerk and Recorder's Office and Frank, our Assistant County Manager. At this time, I will, I believe that's correct. What did I just say? Thank you for correcting me, Assistant County Attorney. Thank you, Frank. At this time, I will turn it over to our Community Development Director, and she can introduce her colleagues and then and say a little bit about protocol and how we conduct ourselves, and then I'll speak to the items on the agenda.
Yes, thank you, Mr. Chair, and good afternoon, Commissioners, and to everyone who's in attendance. My name is Rebecca Everett. I'm the Community Development Director for the county. I'm joined today by Jenny Oxmaker, our Planning Manager, Michael Whitley, our Senior Planner, and we have other staff out in the audience. We have Laura Culleton, Justin Curry, and then representatives of Health and Engineering as well. We respectfully request that all members of the audience please silence any electronic devices, and please help yourself to a copy of the agenda, which is located to the right of the hearing room entrance. For those of you who are here to speak on a specific item today, please, at the appropriate time when the commissioners request it, please speak to the commission, the Board of County Commissioners directly from the podium, and please wait to speak until you are recognized by the chair. We do ask that everyone maintain civility, refraining from any audience applause, comments, or disruptions. And please make your comments directly to the county commissioners. We have a portable microphone and assisted listening devices available for those who may need them. When you introduce yourself, please state your name at the beginning of your comments and spell your name if it has a unique spelling. For those who are watching this meeting on Zoom, you will be muted until you are recognized by the chair. And if you wish to speak or to request a consent item to be removed for a full discussion, please use the raise hand function on the Zoom control bar at the appropriate time. Mr. Chair, that concludes my overview of the procedures. Oh, I apologize. There's one more thing I'd like to add related to the agenda. The agenda pack that was posted online had some additional information that was not relevant to today's agenda, that did not relate to the agenda items. So we would ask that anyone viewing the agenda electronically in the packet can disregard all of the information starting on page 119 of the packet and everything after that. Everything before that in the packet is relevant to today's agenda. Thank you.
Rebecca, thank you very much for clarifying that. So now, friends and neighbors, I'll say a word or two about the consent agenda and also what's involved in a discussion item. The consent agenda is generally for land use matters that our understanding is that there's no perceived controversy. We have recommendations from our community development folks in support, and it's more of an administrative thing. And so that is what a consent agenda item is regarding land use. Something can be pulled off of the consent agenda either by one of the 3 commissioners, or if there's someone in the audience who wishes to pull a consent agenda item off the consent agenda. So that's the essence of that. We have 3 consent agenda items that are listed. I'll go through them in a minute. So, one other thing about consent agenda items, and that is that if those that are on the agenda are typically voted in a group, and so there would be a motion to approve all the consent agenda items, and there would not be a full discussion, and that's how that works. If something is pulled off of the consent agenda, or if there's a discussion item like item number 4 on the agenda, then there's a full land use hearing. That includes a presentation from our community development folks, a presentation. Then the applicant has an opportunity to speak to the proposal, and then there's an opportunity for public comment. The applicant then has a chance to offer rebuttal to the public comment, and then throughout the process, we can ask questions of staff, and then ultimately we'll deliberate and do our best to make an informed decision with the proper motion. So consent agenda items and discussion items. I'll now go through the list that's before us, and then I'll ask the question if any of my colleagues wish to pull any of the stuff off the consent agenda. I hope that's maybe with a thumbs up. Is that fairly clear to folks? Thank you. I have a little bit of audience participation before we get to public comment. So the first item number 1 on the consent agenda, amended plat of Lot 3 Ristview RLUP Rural Land Use Project, file number 23-Land 4375. The second item on the consent agenda is the Pew Minor Land Division, file number 23-LAND 4329. The third item on the consent agenda is the PJ Biggis, forgive me if I'm not pronouncing that correctly, PJ Biggis LLC Signs Appeal, file number 23 GNRL 0547. Let me just mention the discussion item, and then I'll ask the question of my colleagues. The public hearing discussion item, there's one, and that is the Linda Vista Subdivision, file number 18 LAND 3743. So with that in mind, colleagues, do either of you wish to remove one or more of the consent agenda items?
I do not, Mr. Chair.
Commissioner?
I do not, Mr. Chair.
All right, thank you. Is there anyone in the audience who wishes to remove an item from the consent agenda? You can raise your hand. Oh. Thank you. Jenny, would you check to see if there's anyone online who wishes to remove something from the consent agenda?
If there's anyone who's online who wishes to remove something from the consent agenda, please use the raise your hand function. We have no hands raised.
Thank you, Jenny. Thank you, folks who are here in person. So at this time, I would entertain a motion. Perhaps Commissioner Stevens, would you offer that motion to approve the consent agenda subject to conditions and all the rest?
Yes, Mr. Chair, I move to approve the items on the consent agenda, subject to the conditions in the staff reports, and further move to authorize the chair to sign the findings and resolutions.
Thank you, Commissioner. That is indeed a proper motion. And any further discussion? Seeing none, all those in favor?
Aye.
Aye. That motion passes 3-0, so we're done with the consent agenda item. If you were here for any of those three items, we have taken action. If you want to hang out for the fourth item, this is your place. You're welcome to do so. So we'll now move on to the one discussion item, the Linda Vista subdivision, file number 18-LAND 3743. And I believe at this time we will turn it over to our senior planner, excuse me, goodness. Mr. Michael Whitley, good afternoon, good sir.
Yes. Good afternoon. Again, I'm Michael Whitley with the Larimer County Planning Staff. This is the Linda Vista subdivision. It is a preliminary and final plat for a one-lot subdivision to remove a minor land division restriction and allow the parcel to be eligible for development. The applicant is Gary Wexelman, and the property owner is Linda Wexelman. So the subject property is a 34.78 acre parcel zoned O open, and it's in the boundary of the LaPorte planning area. The property has an address of 1418 Green Mile Drive, and it's located south of Highway 287, approximately 1/3 of a mile east of the intersection of Highway 287 and Green Mile Drive. Look at it right there. The parcel is Lot 1 of the Wexelman May Minor Land Division, and there's a note on the Minor Land Division plat that restricts development of the parcel until a subdivision application approval is granted on this parcel. So a little bit of explanation about minor land divisions. So a minor land division is a fairly fast way of dividing a property. However, there are some limitations on that. So when you divide a property that has a principal use, such as a single-family home, from the remainder of vacant land, when you divide a parcel through the minor land division process and you get a parcel that is vacant, that vacant parcel cannot be further developed until a further full land division process is approved. And so in this case, prior to the approval of the Wexelman May MLD, this property in the kind of bold perimeter was a 45 acre parcel with a single family home located approximately here. And the minor land division created Lot 2, which contained the single family home, and created Lot 1, which is just under 35 acres. So it split the land into two lots with the restriction that Lot 1 is not eligible for building permits and cannot be further divided or used. You can't pull building permits until there's a land division process approved on Lot 1. So, and again, the minor land division process is a simple process. It's a truncated process that is one way of splitting land, but it doesn't split it so that it's eligible for further development. So the application before you now is a one-lot subdivision that takes this property that's been in this configuration since 2003 and makes it eligible for development. So if this subdivision is approved, this property could be used consistent with the open zoning district, and that would include the construction of a single-family home, and it would be limited to one single-family home unless the property is further divided through a subsequent land division process. So the property will be served by a shared well and an on-lot septic system, and there's a shared well agreement that was approved by the Colorado Division of Water Resources in 2003. So the Colorado Division of Water Resources has sole jurisdiction over the issuance of wells, and so that issue was resolved as a part of the minor land division process back in 2003. So this item was on the Planning Commission's April 20th, 2022 public hearing consent agenda, and that Planning Commission report and associated attachments can be found as Attachment A to your staff report starting on page 77. So when this item was presented to the Planning Commission, it included a request for 2 appeals that are no longer applicable, and I won't get into all the details. So if you looked at the Planning Commission report, it mentions appeals. Those are no longer applicable because of changes of to access that are proposed. So this is a subdivision with no appeals associated with it. So during the Planning Commission hearing, a member of the public asked the item to be removed from the consent agenda to the discussion agenda for a full hearing. There were 3 members of the public who spoke at the hearing. One property owner had concerns about the shared well and wanted assurances that the well would be updated with a new pump, and he expressed a desire to see details regarding the system. And again, wells are regulated by the Colorado Division of Water Resources, and so anything regarding the well would actually go through the state process. There was a second property owner who expressed concerns with maintaining the access road once it's widened, because there is a requirement that the access road be widened. It's currently approximately 10 feet wide, and to bring it up to standards, we are requiring that the access road, as it provides access to this lot, be improved to approximately 20 feet, and that improvement is shown on this exhibit here. There's also a turnaround that would be constructed fully on this lot, so on private property, it's not encroaching into any other adjacent property owner's property. A third property owner had questions about the access to the property because initially, this land division started out a little bit different than how it ended up. There was an alternative access that was proposed that was later abandoned. At one point, there was a proposal to maybe divide this into 2 lots. So it has a lot of history that has been kind of consolidated and simplified through the process. So there was a brief discussion at Planning Commission regarding the shared well that was executed again in 2003, and also a discussion about responsibility for maintaining the improved road. So the Planning Commission did vote to recommend approval of the subdivision, and the motion passed with a vote of 8-0. So since the Planning Commission hearing, the property owner has unsuccessfully tried to negotiate terms for a road maintenance agreement with other property owners adjacent to Green Mile Drive. So typically when a lot is divided and roads are improved, this particular road is a private access road, and we require that the road be improved to bring it up to current standards, but then also we require that it be maintained. There's typically a road maintenance agreement where adjacent property owners have to come together to agree who's going to be responsible for maintaining and shared costs and such. So the property owner has just reached an impasse with neighbors. The Development Services team has discussed this issue with the county attorney staff, and we have decided that this application can move forward without a road maintenance agreement. There is a requirement that the road be maintained, but henceforth after that, it is considered to be a civil issue with regards to who actually pays to maintain that. We tried to, kind of require that agreement. It was not successful, and so we are comfortable moving forward and letting it be a civil issue after the road is improved. So, the minutes from the Planning Commission hearing can be found as attachment B, starting on page 248. We do have a recommendation in the packet. So the Planning Commission and Development Services Team recommendation can be found on pages 75 and 76. It includes 8 conditions of approval. I do have a slide that lists all 8 of those conditions. I'm not going to read them here, but we can circle back and, kind of get into any, kind of level of detail you cared to, should there be questions. We do also have a suggested motion on page 76. And that motion is, I move that the Board of County Commissioners approve the Linda Vista subdivision, file number 18, land 3743, subject to the 8 conditions found in the Planning Commission and Development Services Team's recommendation. So that's a fairly brief overview of what was a very complicated project that has been kind of simplified through time. I'd be happy to answer any questions.
Thank you, Michael. Thank you for your presentation. Colleagues, this would be an opportunity to ask questions, provide some feedback. Do either of you? Yeah, Commissioner Stevens.
Yeah, I have a question. With regard to the road maintenance issue being a civil issue, so do we at some point need proof that that's been resolved at all, or that really is truly just between the neighbors and we don't get involved in that? And if it needed to move forward or they needed some kind of legal remedy, they would seek that on their own?
I will defer to county attorney staff on that one.
Thank you, Frank Hag from the county attorney's office. The situation as it is, there's legal right to use the road. So it's not a question of do you have legal access. We are also requiring them to bring the road up to the standards that would be required of anybody else doing this. The problem in this situation is that you've sort of already got a subdivision, and then you're trying to get another lot into the subdivision that they can't agree on who should pay what or how you should sort out the road maintenance agreement, which puts us in a position where the options are essentially either don't let anybody ever develop that lot until they pay or work it out, or you just say the road's going to be improved. You will need to find some way to solve this problem amongst yourselves and allocate the cost of that maintenance, which is the road that they're responsible for maintaining anyway. And so that's sort of the situation that we're in. We don't need proof of it. It's going to be their responsibility, the property owner's responsibility to work it out, because it's not and it's not our ability to get in there and tell them you pay this much or you pay that much.
And we have a lot of situations like this in the county where there's, there might be disputes over who's paying for what with regard to road maintenance, and sometimes they're resolved by creating a improvement district, and other times they go unresolved for quite a few years until it's.
That's correct. And the other thing, just to mention is, it's important to think about what is the question being asked of the board today. And the question and the criteria that are before the board today, and the questions that we ask when you get a subdivision is, do you have legal access? Do you have sufficient fire access? Is the road of a standard or going to be of a standard that is adequate for all of those things? We don't typically get in the middle of negotiating who ought to be paying how much every year for road maintenance.
Thank you for explaining that, because if we heard from members of the public and that we should disregard that as one of our, that shouldn't be part of our criteria when making a decision here.
Yeah, I think that's right. The board needs to stick to the criteria, so unless the comments or the considerations have to do with the criteria for this application, then it wouldn't be relevant to this consideration.
Thank you.
Thank you, Commissioner. Commissioner Shattuck McNally, any questions or comments?
Yes, Mr. Chair. So I just want to make sure I'm understanding, Mr. Whitley, kind of your presentation. This was already kind of a subdivision that had been divided, and it said it could not be further divided unless it came back to do this process again. And so we're in this process again, but it could be further divided down the road, and this could be an ongoing issue for access, is my understanding, because that lot looks like it's surrounded, and what's the minimum size it could be, continued to be divided down to?
So the current lot is just under 35 acres. The minimum lot size in the zoning district is 10 acres. So there is the potential for it to be further divided to allow for 2 additional dwelling units. The applicant actually, as I mentioned briefly in the staff report, at first was considering creating 2 additional lots, but because of complications with that, they decided to just go with the 1 lot and basically take the current configuration, again, that's been in place since 2003 with the approval of the minor land division, and just make it a lot eligible for development. And so this process is what that's being used for. It would be possible for the property owner to turn around and propose a further division, or for the property to sell and for the new owner to propose a further division. I'm not aware of that proposal kind of looming, but that would be a possibility. Now, it is a little bit different situation if you're adding lots. And so if you're adding if you're adding more than 1. So we would have to evaluate that if they wanted to create 1 or 2 additional lots beyond what's being requested. And maybe the road maintenance issue comes up again. We would have to tackle that when and if it came up, but we're comfortable with the solution as it is proposed today.
That's,
What's that? Oh, and yes, actually, Rebecca had a good point. So a future land division would go through a full public hearing process, and it ultimately would be up before the Board of County Commissioners for approval or denial. So every issue would be, decided by the board in terms of to approve the subdivision, to not approve the subdivision, to approve it with conditions, what kind of requirements would be attached to that.
and just to clarify, make sure I heard this correctly, that they have been trying to negotiate this road agreement or work with neighbors for how long? How many years?
The planning commission hearing was in April of 2022, and that's, I believe the issue was, kind of discussed prior to that, but that's when it became, that's when it came to our attention, kind of that there was an impasse. Now, I will say that at that time, there was a different planner who was attached to the project, and so that planner has since left Larimer County, so I don't have a deep understanding of all the conversations that went on. I know, kind of the basics. I don't know when the negotiation with regards to road maintenance began, but that's when it was raised at a public hearing, April of 2022.
That's helpful. I guess that's all I have for right now. Thank you.
Thank you, colleagues. Thanks, Michael. I have a couple of questions. First one is regarding this matter of the road maintenance and whose responsibility it is. how does this situation relate to the condition of approval number 7? Because there, the way I'm reading it, an executed development agreement, engineer's opinion of the cost of for public improvements, an acceptable form of collateral, et cetera, shall be submitted. Are these two issues linked? And if so, could you explain that?
They are sort of. So actually, the condition of approval in the Planning Commission report also included the requirement for a road maintenance agreement. So they're related in that the opinion of cost is what the applicant's engineer has to tell us what it's going to cost to improve the road. And then the road maintenance agreement is usually a separate document that says, okay, once the road is improved, who's going to maintain it and what the mechanism is going to be for maintenance, who's responsible for paying for it, et cetera. And then the development agreement is still going to be required. So a development agreement lays out the responsibilities of the property owner with regards to the division. So it includes usually reference to the road maintenance agreement. If there is a road maintenance agreement, it will include a reference to the opinion of cost. It will include a requirement that the road improvements be made within a certain amount of time. They'll have to post collateral. There will be warranty collateral. There are going to be conditions with regards to, kind of radon, fire protection, et cetera. So some of the things that are in a little bit further detail in the Planning Commission report, those are intertwined, but we did remove the reference to the road maintenance agreement because we removed that from a consideration as a part of this application.
Thank you, Michael. That's helpful. Did you say that when the Planning Commission heard this proposal back in April of 2022, did they recommend that a road maintenance agreement be finalized?
That was not a condition that was
Okay.
attached to the recommendation. There was discussion about the road maintenance agreement, and at the end of that hearing, there was an assumption that a road maintenance agreement would be required, and that's part of the reason that this hasn't gone forward to the Board of County Commissioners since April of 2022. After that hearing, we turned it back to the property owner and said, you do need to resolve this. They came to an impasse. They approached staff again and said, hey, how do we move forward without this? That's when staff, including the engineering staff and planning staff, began discussing the issue with the county attorney's staff.
Thank you. Thank you, Michael. Two more questions, if I may. One is on the matter of the shared well and the water issue. Did you say, or is it in our packet, that the Colorado Division of Water Resources has indicated that there's adequate water to do this subdivision?
They have, yes.
Okay. Then my last question is, for the record, can you tell us why the LaPorte Planning Advisory Committee was not able to weigh in on this discussion?
This was on an agenda for the LaPorte Planning Advisory Committee, but there was not a quorum for that particular meeting date, and that was before the Planning Commission date. So typically, when this goes through a review process, after staff review, it would be scheduled for the LaPorte Planning Advisory Committee. Then comes the Planning Commission hearing, then comes the Board of County Commissioners hearing. And so because there wasn't a quorum, it moved forward to the Planning Commission without a recommendation from the LaPorte Planning Advisory Committee. And we just kind of moved that forward from Planning Commission to the Board of County Commissioners without circling back and taking it back to the LaPorte Area Planning Advisory Committee after Planning Commission. That would have been a little bit out of order.
Thank you, Michael. Thank you for answering my questions so that I can understand your answers.
Oh, you're welcome.
So colleagues, do you have any additional questions or comments for our staff before we go to the next step of our land use hearing process? Yes, Commissioner.
Thank you, Mr. Chair. I just want to go back to the well approval. You said it was 2003,
Correct.
and, that's 20 years ago. Just curious how long those, approvals go, because water conditions and water tables change, and I'm just wondering about, is that for 2 wells now? Is there a certain length of time for something to be approved for that changes with drought conditions and wells change and conditions changing? I'm just curious about that.
So I am not aware of an expiration of that shared well agreement. I do have access to it. Typically, when a shared well agreement is executed, it's valid perpetually until revoked. This application, the 2018 application, was referred to the Division of Water Resources, and the Division of Water Resources acknowledged that shared well agreement, so they had no concerns with the proposed land division.
And that was out without further review or inspection of the well or anything like that, or did someone go out and, at that time when they referred that to them, go out and check or?
I don't know if there was a physical
Okay.
inspection of the well, but based on the available information that they had, because they do make a determination as to whether or not issuing an additional well would have a detrimental impact on any well in the vicinity, or in cases of a shared well, on the well that was already approved. And the Colorado Division of Water Resources made a finding that the shared well agreement would be appropriate, and that there is adequate resources for this particular shared well arrangement.
That's helpful. Thank you.
You're welcome.
Great, thank you. We'll now move on to the next portion of our land use hearing for this land use proposal, and that's where the applicant has an opportunity to make their case regarding this proposal. And Rebecca, correct me if I'm wrong, but typically we could give up to 10 minutes, is that right?
That's correct. That's typically been the standard of the board.
Okay, great. So at this time, I presume the applicant is here. If you folks want to come on up to the podium, we're generally nice folks, and if you would introduce yourself and present regarding this application, and it would be helpful to, if your last name would help our clerk and recorder to spell your last name. And again, welcome to our hearing.
Sure. Yeah, I'm the applicant. My name's Gary Wexelman, spelled Weixelman. Yeah, we started this process.
And I'm the owner.
Yeah, let me introduce my sister. Sorry.
Linda Wexelman, same spelling. Linda with an I, Linda.
Great. Welcome, folks.
Yeah, brother and sister. We started this process quite a few years back, and glad to make it this far. I believe we've done everything correct that the county wanted. We've turned in the engineered reports and had a hydrologist and Wayne's Pump Service, also with the expert on the well, do a pump and recovery
Gary?
test.
Forgive me for interrupting, but could you talk a little bit closer to the mic? So
Sure.
I want to make sure I can hear both of you folks.
No, that's fine. I'm sorry. Is that better?
Yes, sir.
Yeah, we've tried hard to jump over every hurdle and get all the dots on the I's and every T crossed on the entire process. And at one point, we did have Wayne's Pump Service do a pump and recovery test on the well. And I believe we've got a copy of that report in all the stuff that we've turned in. And it seemed like it was adequate in their opinion at that time. And that was within the last 10 years. I don't think it was maybe 5 years ago. And then on the shared road agreement, we tried a couple of times. I'm still open to any sort of a shared road agreement that the owners would want to join on. I think the shared road agreement makes sense, but in the end, we'd like to get approval and be able to put the road in that would meet the county standard, and we can figure out how to maintain it, I'm sure.
Thank you, sir. Linda, is there anything you'd like to add?
I feel like everything has been addressed, and I feel that there are no questions at this time.
Oh. Colleagues, opportunity if you have any questions for the applicants? Commissioner?
I don't have any, Mr. Chair. Thank you.
I don't have any at this point, Mr. Chair.
Okay. Well, so again, just as a reminder, folks, in a moment, we'll open it up to public comment, and folks can, they have up to, I forget, 3 minutes or so to offer public comment, and I would encourage you to pay attention to those public comments. Then you'll have an opportunity to come back and respond to those comments. Okay,
Okay.
thanks a lot.
Sounds good. Thank you.
All right. At this time, we'll open it up to public comment. And I don't have a sign-up sheet or anything like that, but are there folks in the audience who wish to offer public comment? If so, please raise your hand. We have about 4 folks, okay? The person who is standing up, come on up. If you would be kind enough to introduce yourself, any affiliation perhaps, if your last name would help us to spell it correctly, and then you have about 3 minutes.
Okay, for sure. Thank you so much. My name is Jessie Weiner. That's JESSEWEINER. When we bought 4406 Green Mile Drive in 2013, that's the neighboring parcel, it was as raw land and with the understanding that the neighboring parcel would remain an open space as it was and is currently classified in the county records. We have since built what we intend to be our forever home, and at no small cost. If the county does agree to pass the subdivision, the value, both the personal and perceived value, both the personal perceived value and the actual resaleable value of our home will decline. Not to mention the fact that we didn't move out to the country to have someone else's door a stone's throw from our own, which will doubtless be the case as the only place for an economical build on that parcel is at the base of a mountain, right beside the property line. Personal preferences aside, there are legal and economic questions to consider. Our current word-of-mouth road agreement works great for us. Also, we have had minimal contact with the seller and the representative. We haven't heard from them in over a year and a half. At that time, they asked to have part of our land to be able to be turned into a big turnaround circle, to have, not to buy from us. We declined that offer. Currently, my husband and our neighbors maintain the road, both with their wallets and on their tractors. Over the last 2 years, our household has spent 2 years, $5,000 in crushed asphalt alone. And again, that's just our household. That's not the portion our neighbors are paying in. If the road doubles in width and complexity, a change we do not welcome, that expense could come to $10,000, if not more, thanks to inflation and the difficulty of upkeeping a road with a higher standard grade. If the requirement for a road association is removed, with the onus of maintaining the road to be placed entirely upon either the next owner of the parcel or us, to whom do we turn if the owner fails to meet this requirement? To whom do we turn if we cannot meet an agreement? Will the county then pay to maintain the road? I think I've already had that answered. It becomes a civil issue. Sounds like we'll be stuck paying for it anyway, and at a greater cost of both our finances and our time, just to ensure that visitors can still make it to our home and that our milk packages and other deliveries won't have to be left at the exit off the highway. And more questions. Will there be a time frame in which the said owner will be legally required to maintain the road? That is, if the cost of maintaining the road is to be put on the developer. Again, if they fail to make necessary improvements within that time, what recourse do we have, if any? Do you mind if, was that my timer?
If you could just kind of wrap it up, closing.
Sure, yep, I'll be quick.
Very quick.
In 10 years, Brian may not want to be out riding tractor. What if the new neighbors don't have the physical fitness to help? Or what if our neighbors can't pay to maintain the road at any point? Previously, our road had been nearly 20 feet wide due to high traffic, mainly from a horse rescue, which has since moved. People commonly mistook our road for a county road, ignoring the no trespassing sign to park and relieve themselves. We set up stakes and spread grass seeds, successfully narrowing the road to its current and healthy 10 feet, and we've seen a decrease in trespassing. I fear that if we widen the road, this trend will be reversed.
Jess, could you wrap it up? Forgive me. I'm just
Yes.
trying to be fair for everyone,
Yep,
please.
I ask you to consider why support a subdivision which currently only benefits one person and at a considerable detriment to those of us who reside there. Thank you.
Thank you kindly. All right. Who would like to go next? Yes, welcome.
Hi.
Hi.
My name is Claudia Schimmert, CLAUDIA SCHIMERT. My partner, Brian Darrington, and I purchased the property, now known as 4317 Green Mile, in 2003. Our property used to be known as 4317 West County Road 56, but back in around 1980, Larimer County vacated the section of West County Road 56, which was to the south of the newly constructed Highway 287. Upon being vacated and abandoned by the county, that section of West County Road 56 no longer existed, and the access to our property was replaced with a private access easement known as Green Mile. Over the last 20 years, 3 of the 4 landowners on this easement have contributed to the maintenance of this easement road. The 4th landowner, which happens to be Linda Waxelman, has not contributed a dime of her money, nor has she contributed a minute of her time to maintain this easement. The 4th landowner is now coming forward to request that her agricultural parcel subdivision be approved as a buildable single-family parcel residence. To our knowledge, prior to approval, Larimer County has made a requirement that the existing private easement be upgraded to county road standards, which would make the new physical road twice as wide as the existing physical road. It also requires that the residents on the easement maintain the road to county standards in the future. Larimer County has made it clear they have no intentions of sharing in the cost or the maintenance of the new road. The only person that will benefit from this requirement is the applicant, as it will allow her to make her parcel saleable as a buildable lot. The 3 remaining landowners have absolutely nothing to gain from the road requirements and will ultimately be required to pay for its maintenance, which is estimated to cost at the very least twice what the existing physical road will cost in the past. In addition, the current road, because of its size, has been manageable for the current landowners to maintain, but the increased road size that meets county road standards will exceed our capabilities and require that the work be hired out to a contractor that will add considerable cost to the other 3 residents. Keep in mind that the increased cost will have no benefit to us and will be money coming out of our pockets, our paychecks, Social Security and retirement checks for as long as we live here. The county road requirements have no benefit to the county and will not cost the county anything, but will shift the burden and expense on the neighboring residents, which is unacceptable. I personally don't think that the county has the right to this requirement, as they vacated this road a long time ago. If the county does not intend to take on the future increased cost of their requirements, then they need to withdraw the requirements and leave the road as it is, or deny this application. I ask each and every one of you to put yourself in our place, in the position of the neighboring owners, and clearly understand the negative impact if this application will have on us if approved with the proposed road requirements.
Thank you, Claudia.
Thank you. So all we're doing is,
Yes, please.
Okay.
I'm just
Thank
trying
you.
to be fair. Just. Howdy.
Hi, how are you?
Oh, I hope that's good.
Me too. My name is Gary Becker, Becker.
Welcome, Garrett. Please begin.
Well, the way to start, I bought this property before 2000. I've been there forever. Most important is the understanding of where you're at now. I don't quite understand how individuals come in and say they want to do this when there's no participation, with the exception of about a year ago, this gentleman, the applicant, one of them, asked for want us to buy the business or buy the property. Well, first of all, the property is good for goats because it's nothing but half of it's a mountain. So you think about this, and the real issue is this. is finding out how they got this permission to do this for one reason. And I understand one person, I understand that. But for developing something that we have supported 100% is confusing. So anyway, I'll take a minute, but that's it. But it's really trying to understand how they did the water thing automatically. The Laporte thing, I went through the Laporte thing. They're concerned. Nobody brought them in. There's some unanswered dotted I's and crossed T's. Thank you very much.
Thank you, Gary. Welcome.
Good afternoon,
Good afternoon.
ladies and gentlemen, commissioners, associates. My name is Brian Darrington, with an I, Brian Darrington, Derrington. Thanks for this afternoon. I live at 4317 Green Mile Drive, Lot 2, adjoining Lot 1, along with Claudia Schimmert. She stated our facts pretty eloquently. I would only like to add my opinion on the road agreement. I have a document here that had road utility easement. If you would like to have it, I've got copies for you. In this statement, in this document, in section 2 and 3, road utility easement, and in section 3, the parties to this agreement may construct, improve, repair, and maintain road utility easement and appurtenances at their own expense, and have no rights to seek reimbursement or any form of compensation from any other party to this agreement. So this agreement is a real simple agreement that if I want to work on the road, I'll go pay for it, I'll do it. If I get approval and additional expenses from the neighbors, and we discuss that, we do it. We have done that for the last 20 years. It works real well. That's the road agreement we have, handshake, as Jesse had mentioned. So my only option to this, or option for this, would be that we disregard the requirement for upgrading this to a county road standard. Leave it private as it is at 10 feet wide plus. We maintain it. We're happy to do that. It's my tractor therapy. I enjoy it. So I'm not opposed to their selling of the lot. That's their right to do so. I'm happy that it's gone from 2 properties to 1. We have the shared well agreement with that property. That's been in place since we bought the property. We're well aware of that. I think that's conclusion that I have. Again, if you want the document that I have on that regarding that agreement, I'd be happy to share it. Thank you very much.
Thank you very much, Brian. Thanks for the public comment. Is there anyone else here in person that wishes to offer public comment regarding this proposal, this subdivision proposal? Then we'll check online. Jenny, is there anyone online?
We have no attendees online.
No attendees? Thank you. Then we will close the public comment period. And as I mentioned earlier, this is now an opportunity for the applicants to respond to some of the issues that were raised. So if you folks would come on up. It's kind of how it works.
Sure, I'll go first. On the shared road, I apologize for not trying to work harder with the neighbors, but I sent them emails with proposals of a shared road agreement. We're happy to participate in the costs that they've laid out in the past. I asked them for bills. What did they spend? Can we put in our share? No communication was returned. Never did we get a bill. we'd be happy to discuss with the owners, of the neighbors, the people next door. That's where I apologize we haven't been able to work things out. I'm not sure why we came to this. Having said that, yes, we would pay the entire cost of building the road. That would be on us, correct? We'll actually have to put up a bond to ensure that the road's done to the county specs. Sorry, we have to build it 20 feet wide. I'm happy with 10 feet, but the county wants 20 feet, and we look to get approval on the lot to make a buildable home site. The neighbors all bought their property through us as a family. When they bought the property, they knew Linda had the land there. They knew Linda's intention was to someday build a home or sell it as a buildable home site. I'm a little confused by some of the comments. But yeah, I look forward to working with the neighbors and getting a road that would meet the county standards, and hopefully we can work things out.
Thank you, Gary. Linda, anything you want to add?
Just that I'm in complete agreement. I would like to see a road agreement reached, whether it has to be required or if it's not required. I think we're capable of that. Every intention to contribute, as Gary said. The property was never to be open space. In 2000, the shared well agreement, all of this, at no point in time did I say I want to have a park. It is an investment that we've worked a long time to find a conclusion to, and that's what we're hoping for. And I thank you for your time. Do you have any questions for us?
Sure. Colleagues, do you have any questions for these folks at this time?
Not at this time. Maybe later, but not at
Well,
this time.
Okay, thank you. So now we can see if there are any questions for staff. I have a couple, but we'll start with Commissioner Stevens.
Yeah, so just a few questions from what came up from public comment. So I think my guess is that when Jesse was speaking and talked about it being zoned as for open space, I think that it was just zoned open, and that doesn't mean open space. So is that kind of your reading of maybe how the confusion happened?
That's likely the confusion. So the open zoning district is the most common zoning district in unincorporated Larimer County. Approximately 90% of the land in unincorporated Larimer County is zoned open, and there are a couple of different ways that people misinterpret that. So the open zoning district is really a agricultural and single-family home zoning district that allows a variety of agricultural uses and one single-family home per parcel. So some people see open and think, oh, open space, as in never developed. And some people actually more commonly, when there's confusion, they think open as in anything goes. I can do anything I want in that zoning district. So if there was confusion, that is likely the genesis of it, but it was never designated as an open space parcel. There's no indication in the minor land division application materials that it was perpetually set aside as open space. It's clear, kind of from the county's perspective, that this was intended as a vacant parcel that could be further divided, which is the process we're in now, and could be further developed if that further land division approval is granted by the Board of County Commissioners.
Thank you. And then, several people suggested kind of leave the road as it is. I mean, I think that would lower, obviously, maintenance costs. But that is not possible in this situation, is it?
Well, I have thoughts. However, I would defer to Frank Haug for the legal opinion and Stephen Rothwell with the engineering department for the engineering department's perspective on the importance of the road improvements.
Okay, thank you.
Stephen Rothwell, Larimer County Engineering. I think I can help a little bit there. So just one clarifying thing. The road standards that we told the applicants that they would need to implement for Green Mile Drive are our minimum Larimer County Rural Area Road Standards, private road standards within Appendix G. They are not the standards that would be required of a public road in Larimer County. So this is the minimum standard that we would look to for access for emergency personnel, deliveries, safe two-way traffic, and a turnaround at the end. So really, on our end, this is the minimum road standard we'd be looking for multiple lots.
I don't have a ton to add to that other than, the main issue that the county looks at and engineering looks at is you have your road standards, but you want to make sure that emergency vehicles can access the property. You want to make sure that you have sufficient, largely that, right? That there's enough way for the fire departments and people to get in and out. To the, it's a difficult situation, but the county looks at, there's no question in this situation, is there legal access? Yes, there's legal access. There's no question about, can they subdivide it? They can apply to subdivide it. The question is really just how do you distribute the costs of who's going to maintain what? And in an ideal situation, when you do a subdivision, you do it all at the same time so you can solve all these problems and require all these things to happen. In these situations with these land divisions, like happened previously with this, you sort of punt on some of those things until later, and now we're in a situation where we're having to deal with the fact that it got punted earlier.
And so the reason it's having to, being upgraded to this rural road standard is because it would be an additional home that would be being built, and that triggered that. The other homes that are around here, so it looks like there was at least 3 different folks. Is there a minimum number of homes that trigger that on that have access to a road? I mean, why all of a sudden, the road was existing. Why, with the few homes, seemed to be okay, and now isn't? Like, what's the difference?
It has to do with how old the road was when it was constructed and whether or not Larimer County had a process for the private road to be built out. So currently we have a private road construction permit, and we would require any new roadway that's going to be serving more than one single family residence to meet that minimum Appendix G standard. Back when the road was originally created, that process did not exist.
Okay, that's helpful, because I didn't know. And it's for emergency and other,
Yeah, so our Appendix G standards were written in collaboration with a lot of the emergency service providers in the area, and we really tried to minimize the requirements. So it truly is our minimum shared access standards.
And then I was going to try to address some of Mr. Becker's questions. I didn't really know. I guess it didn't go to LaPorte because there was not quorum, and so then it went directly to Planning Commission, and there was no reason to go kind of backwards then in that process. Is that correct?
Correct.
Okay. I'm trying to think if he had other questions. But they are allowed to develop this property in this way. I mean, and they do, and according to staff, meet all the criteria that's laid out for this.
From a staff perspective, yes.
Okay, thank you. That's all I have.
Thank you, Commissioner. Before we go to Commissioner Shaddock McNally, I wanted, if I may, just quickly follow up on the road questions and the answers. I think one of the folks commenting, maybe it was Claudia, suggested that bringing the road up to the minimum rural road standards would double the cost of maintaining that road. Do you have any sense of that?
I can tell you that if it's a little different from how the county would operate road maintenance versus how the current neighbors are operating. So I don't want to say that I'm disagreeing with them, just because we are not in a position to be able to say, go out and grade it ourselves, for just time and not a cost. But if it was, say, a PID or a public improvement district, the main cost is mobilizing the equipment out to the site. It's the labor hours of running a motor grader or other similar equipment. Generally, the material cost itself isn't the key factor. I ran some quick numbers and I had estimated about a 15 to 20% increase in cost. But granted, you're also getting one more contributor. So currently there's 3, there would be 4. But again, I can't speak specifically to the numbers that the neighborhood's seen.
With the permission from my fellow commissioner, just one additional follow-up, and thank you, Stephen. That's actually really, really helpful. Regarding access for emergency vehicles, fire trucks, and things like that, we haven't necessarily reached out to them at this point to see if the way the road is configured now would ensure that they could get in there if there was a situation.
Michael, I might have to ask for your help on this one. I don't recall what the fire department or the emergency service provider's comment said.
And I would have to look, but this was referred to the Poudre Fire Authority, and they did comment. And so typically with land division applications, they comment as to their minimum standards. I haven't specifically looked recently, but my recollection is that, yes, they commented that the road would need to meet minimum standards, which again, would be that 20-foot wide surface.
Okay.
But I can double check on that if you care to, for me to.
You mean double check on it while we're in deliberations? Yeah, please do. Yes, Commissioner, thanks for your indulgence.
Mr. Chair, I just want to add, as I see on page 105 or page 2 of 2, the fire lane suppressions, which I was reading that it was a road which should be 25 feet inside the turning radius, the turning area. So I read that there was a certain specific from the fire for the radii for the turning and the fire lanes. So I'm just wondering if that correlates with what our turning area was and things. So.
And there was an alternative proposal that was approved for, rather than do a turnaround, so the original idea was that there was going to be basically a cul-de-sac that one of the property owners mentioned that they were approached about giving up some land for that cul-de-sac. So rather than, because they're only pursuing one additional lot, as kind of creating this as a developable lot, as opposed to dividing that 35-ish acres into more than one parcel, we have approved a turnaround proposal that is fully on the proposed lot that does not require that bulb. And so my understanding of the kind of comments is that that satisfies the Poudre Fire Authority and the engineering department.
Okay, that's helpful. I appreciate that because that was one of my questions. If I might.
Yes,
continue.
please. Yeah, sure.
Thank you. So I'm repeating this again. I know Commissioner Stevens already asked this question, but I'm just trying for clarification for me. Because this seems to be kind of complex and complicated, and there was a pause, and it didn't go to the Laporte PAC, and then it kind of skipped around, and it seems like, as I'm understanding, really the holdup was some changes, and then this inability to have this road agreement going forward. How many? So first, that's my first question. Is that really why this has been delayed so long? Is because of this road agreement? I just want to make sure this is kind of why this is. If this was back in April of 2022, that it's till now. Just curious.
In terms of the gap between Planning Commission and this hearing, yes, that was the result. The inability to come to an agreement with the road maintenance was the the cause of that gap. So, and just a little bit more explanation. So at the time it went to Planning Commission, there was a planner assigned to it. And at the conclusion of the hearing, there was an understanding that the property owner would reach out and negotiate the road maintenance agreement with the surrounding property owners. That planner left. This file was, kind of still active in our system, but it did not have a planner assigned because there was nothing happening with it. And so it only got assigned to me when Mr. Wexelman reached out and said, hey, we would like to move forward even though we have not reached that agreement. So that's when the conversations began. And I first brought the issue along with Stephen Rothwell to Mr. Haug as staff to ask the county attorney's opinion about moving forward last August. So there was a large gap, much larger than usual, because of that kind of limbo. But once we began the conversation about the road maintenance agreement, that's where we discovered that there would be a path forward.
Okay, that's helpful. Do we have this, and I understand about the minimum standards, that it makes sense to me. Do we have a lot of PIDs, but do we have lots of these other informal road agreements or associations and other applications or land, divisions where, it was a private road and is this kind of a standard or something that is required to kind of, because you said this was at the end, was going to be negotiated. Is this something that we see a lot? Is it something that is required, or was that just kind of attached at the end of that to kind of address this for this part?
The road maintenance agreement is a standard requirement when you're dividing property. What makes this situation a little bit different is that it's part of a minor land division. This lot was created through a minor land division process. And so it was created in its current configuration without the requirement for a road maintenance agreement. If this 45-acre piece had been divided, kind of fully through a full land division process, probably there would be a requirement for a road maintenance agreement. So this is a little bit of an unusual situation.
That's helpful, because as I understood, that was a requirement, but then I'm just trying to understand why I'm trying to understand the why of why we're in this kind of unusual circumstance with this. So, okay, I think that's all I have. Thank you.
Okay, thank you. Oh, and to follow up on Commissioner Kafalis's question, so I do have the Buda Fire Authority's comments before me. They can be found on pages 104 and 105 in your packet. And there's a lot of extra detail, but they do mention one of their fire lane specifications is to maintain a required 20-foot minimum unobstructed wide and 14 minimum overhead clearance pathway. So the Buda Fire Authority's minimum standard is 20 feet unobstructed with a 14-foot high clearance. So you can't have like an overarching sign or anything like that.
Thank you. Yeah, I
welcome.
see that as well, Michael. Thank you.
Thank you.
Just a couple more questions, and I might have a question for the applicants. So, did you say a moment ago that one option for addressing the Buda Fire Authority requirements for access, emergency vehicle access, is a cul-de-sac configuration versus a turnaround? And if I heard that correctly, is that a less intrusive or a less expensive option? And I may not have heard that correctly.
Yes, and I'm going to share my screen here so I can show you the ultimate negotiated turnaround. So, the initial conversation was to develop a cul-de-sac bulb, and actually Stephen Rothwell would know exactly where that was, but it would be a cul-de-sac bulb that would allow vehicles, emergency vehicles or otherwise, to come in and turn around, and that would require additional land from adjacent properties. What has been negotiated is what they're calling a hammerhead, so that there is the ability to pull onto this property and then pull out. And you can see the hatched area, the wider hatched area, is the road area that is proposed to be improved. And so this is an alternative to the cul-de-sac. Now, again, if this land had been proposed to be divided into 2 or 3 additional parcels, almost certainly there would be a cul-de-sac bulb somewhere along the frontage of Green Mile Drive. But because this is only one lot, almost 35 acres, that is eligible for one additional one additional single-family home, this was the alternative that was negotiated that, correct me if I'm wrong, Stephen, meets county standards and has been agreed to by the Poudre Fire Authority.
Thank you. So I'm understanding there, Michael, that this alternative proposal could address what the Poudre Fire Authority is requiring and perhaps be less intrusive on some of the other properties. Did I get that right, sir?
Yes.
Then I have another question, and that is, I think one of the comments, and I believe we clarified about the zoning and zoning versus open space, but is it correct that this is a 35-acre parcel, and it's proposed to be subdivided so one home can be built on this 35-acre parcel? Could that be done in such a way that would preserve a lot of that open space? I forget what we call it, a particular conservation
Yes.
development type thing.
We do have a process called a conservation development, but that is actually, there was a previous approval, a previous Board of County Commissioners granted an approval to proceed with this as a one-lot subdivision as opposed to a conservation development. So in unincorporated Larimer County, the standard, if you want to divide a parcel that's 30 acres or larger, you go through a conservation development process where, through that process, you set aside a percentage of the land, depending on the circumstances, either 50 or 80% as perpetual open space, and then you can develop the rest with residential development. There was an appeal granted by the board, previous board members, that allowed this one-lot subdivision in lieu of the conservation development.
If we were to go back to the idea of a conservation land development, would that mean we'd have to start the process all over again?
That would be a completely different process.
Yeah.
But again, an appeal to allow a one-lot subdivision as opposed to a conservation development had already been granted by the Board of County Commissioners.
Prior. Okay. Then I think that's all I have for you, for staff. Would you guys, Linda and/or Gary, would you come up? I just wanted to make sure I heard something correctly. I may not have, because I don't always hear things.
Yes.
Oh, yes, thank you. In your rebuttal or response to the comments, did you folks suggest that regarding the road maintenance agreement, that any additional costs, looking at the T proposal, that you all would cover that?
Well, we would put in the roads to the county specs. We would build the T turnaround, or the hammerhead, would be on Linda's property. And it would be built with the gravel required to the width that was required for the minimum county standard, is what our goal would be. Yes.
And we would we would pay to have the road widened back to the county standard.
Would you also take a greater responsibility for maintaining the road, or that's just to do these changes?
Well, it's my understanding, what makes sense to me is that if you have 4 people, it should be split 4 ways. But my understanding is that I guess you could have a lot of elements.
We're willing to contribute to snow removal and maintenance costs right now. We've never seen any bill. So, and I've asked for a bill a couple of times, more than once, through emails and electronic means. But, yeah, so in the end, we would keep it up. We would be happy to chip in and do our fair share. You bet.
Thank you.
Okay, and just
Do
one
my
other thing.
co-
We've been at this process for quite a while.
Yes.
Way back about the time that Claudia bought her piece in '03 or something like that, there was a neighborhood meeting and there was a Laporte meeting, and my understanding was we got approval, but that was commissioners ago and planning staff ago, and we've been working on this for over 20 years.
Thank you. Colleagues, do you have any questions or for these folks? Thank you very much.
Thank you.
Any additional questions for staff? Commissioner Stevens or Shattuck McNally? Yes.
I just want to maybe ask staff about the statement the applicants just made. This has been going on for even, sounds like many Laporte planning committees or planning commissions and boards of commissioners. How many years has this been going on, and is that matter? Is this a new application? Is this previous application? Has this been a long-term coming through lots of different changes, and is there approvals you haven't spoke of, or are we talking about this application started on this date? I'm just curious, because it sounds like they thought that previous boards had given them, they'd had previous approvals or something.
Well, the previous approval, there have been a couple. So there was an approval in 2003 for the minor land division that split that more or less 45-acre parcel into 10 acres on the south side of Green Mile Drive, and the 35 that we're talking about today. So that was 2003. I would have to look and see, but after that, there was quite a bit of a gap, and then there was an approval to allow a one-lot subdivision for the creation of this lot as a lot eligible for development. There was an appeal to not do a conservation development and allow a subdivision, and I don't recall that date. The subdivision application that you're reviewing now was submitted in 2018, and so with those land division applications are multi-step. And so it began with what was called sketch plan, which was in 2018. And again, back at the sketch plan phase, there was a proposal to divide this into 2 lots. And so that was, kind of one, kind of request that ultimately got consolidated to do one. I can't speak to how long it was between sketch plan and when the applicant submitted the public hearing submittal. But it originally came in, this application in 2018. It didn't go to Planning Commission until 2022, working through all those issues. And then there's been another gap of almost a year and a half-ish between that Planning Commission, almost 2 years actually, that Planning Commission hearing and the hearing today. This has been a slow-moving process, but that sometimes happens. This is extraordinarily slow, but there have been multiple steps in that kind of 21 years that it initially started. But I do think there was quite a bit of a gap between this being created through the minor land division and then, well, actually, I can tell you it was 15 years. It was a 15-year gap between the minor land division approval and the submittal of this subdivision. In between that was the appeal to allow the land division through subdivision as opposed to conservation development. So those were the 3 approvals.
That's helpful. Thank you.
You're welcome.
Anything else, colleagues, for any questions, feedback for staff? Otherwise, I think we can move into the deliberation, discussion portion of our hearing. And with that, Commissioner Stevens, would you like to begin that process, please?
Sure, Mr. Chair. Yeah, I'm happy to start. So I appreciate everyone who came out this afternoon, and appreciate staff, because this was, pretty complicated situation, and, we want to get this right. I understand the neighbors' concerns about the road and the road maintenance, and I would just say to all of you, I hope you can figure that out. Talk to each other, figure this out, because I think that piece is important. I will be supporting this subdivision, and because because we're required to not necessarily take into consideration who's going to take care of road maintenance. That's not part of the criteria that we're asked to look at when deciding whether we should do this. It's an existing and allowable land use, which is one of the criteria. It complies with requirements of the code. It has adequate public facilities. So the road will be created to ensure that there's adequate access on the road by the requirement of the 20-foot 20-foot roadway. And so in my feeling and staff's too, it meets all the requirements of a subdivision. So I will be supporting this, but I would say I urge you to look for a solution on the road maintenance, because that's important, and it's important for neighbors to figure this out, and I know that can be really tricky. I'm sorry for the confusion about open zoning, and that apparently has some confusion, so I don't know how we clarify that, but maybe we can clarify that, so that folks really understand what kind of development is allowed in open zoning. If you have further questions, I would, ask you to talk to staff, but because it meets the criteria that's laid before us, I will be supporting this application. Thank you.
Thank you, Commissioner. Commissioner Shattuck McNally, your thoughts?
Thank you, Mr. Chair. This is a tough one for me. It doesn't sit well with me. It feels like it's had a long history, a complicated history, and it just makes me uncomfortable that they keep applying for appeals and keep getting appeals. And a lot of this stuff was kicked, like you said, punted and maybe punted down the road. And now we're here to the point where, it's at this juncture. I understand and listen and really feel for the residents, your concerns. It's really hard for us when we have criteria as county commissioners, and if it meets the criteria, we have to approve it. And it's frustrating for me to have so many neighbors that are uncomfortable or really not happy with this, there seems like they met all the criteria, and we don't have much to do to enforce kind of some other agreement. I think that the appeals in the past just I can't do anything about that, but it makes me really a little frustrated and uncomfortable myself. To have to be put in this position to make a choice that it doesn't sit well with me. And I just wanted to state that. I don't see any criteria that they're not meeting, but I agree with Commissioner Stevens. And the Planning Commission was 8-0 back then, and I really think for the neighbors, I'm going to put this on the applicants to really there's a dispute about who said what or who's approved what, but I really think it's important overall that some kind of collaborative agreement be brought together. It's really hard for us to say, well, that you've got to figure that out. It's a civil matter because this is kind of the circumstances created are from previous boards kind of making decisions that have brought it to this point by punting things. And that I know I'm being a little outspoken about that, but it's kind of a little frustrating for me to have that now to deal with. So I guess I'm really conflicted on this. I've been really trying to listen to hear both sides, but I agree with Commissioner Stevens. I think that they seem to have met all the criteria. Staff I've heard you say multiple times they've met all the criteria, and it may not be something that we have a basis to disallow because this road agreement is not something we can and we can't make it as a condition either, correct?
If we can.
I would defer to the county attorney staff on that.
The problem in this situation is that you've sort of got two options. One is to say to the applicant, you can never develop. Until you satisfy whatever your neighbors want, you can never develop. Alternatively, we can say you need to build the road to the standard, you need to have legal access, and then you guys are going to have to work out how to pay for the road. Because if we get in the middle of that and we say you pay 80%, you pay 20%, then we're negotiating who has to pay what. And that's not a position on a private road that we get into the business of telling people how to maintain their private roads. And so the alternatives are either never let them develop until they've worked all that out, or look, we go through the criteria and we try to look at the application and decide, does it meet the criteria for what they're asking to do? So could you condition it? I guess you could, but in that case, you're going to be negotiating who should pay what amounts. And I don't know what information we would have to make that decision on.
Go ahead.
No, go ahead, Commissioner.
Well, I was going to ask about that. I mean, if we added a condition of approval that didn't require us to figure out who's going to pay what, that a condition of approval, they work out a road maintenance agreement. Can't we do that? And then it kind of puts everyone's feet to the fire in a loving and respectful way to work out a deal.
Well, and Commissioner, I hear what you're saying, and respectfully, that's kind of how we got to this position. That is what we told them. We told them, go work it out. And they've been waiting for years to come back to try to solve the problem. And if they're not, I mean, what we do is we'd say you can't record your plat until you've worked it out. And so then it puts a position where if they meet and they're not able to work it out, again, the lot's undevelopable for perpetuity. And so the problem is, where we're at, is if you say you must come to an agreement before you can develop this lot, if one of the neighbors says, I'm not going to agree to anything, then the lot is never, ever going to get developed. And that's the situation that we're in. And so the question that was presented to the staff and to me was, well, what do we do? Do we move forward and allow them to go forward with the application absent that, or do we require them to meet the road, to get the road thing worked out before they can move forward? And what we decided was, we care that there's fire access, we care that the criteria are met, and we care that there's some ability to get legal access. As far as who should pay what, we don't want to be in the middle of negotiating that.
So legally, can we add that as a condition of approval? And if they can't come to a satisfactory agreement, then it doesn't move forward?
If you add a condition of approval that you must come to some road association agreement, and then the neighbors are not able to do that, this would not be a developable lot.
Okay. All right. Thank you. So, I'm inclined to agree with my fellow commissioners. The relevant criteria regarding, as they pertain to subdivisions, this particular subdivision, and then the various appeals criteria have been met according to our staff, and that's by and large what we have to go by. It's been suggested that I guess we can't make it a condition of approval. We can only more than encourage, ask you to work out something that is agreeable to everyone. In the old days, the idea of being good neighbors and figuring things out, maybe there's a way to, forgive me, Barry, I can't do that. I can't do that, please. I'm happy to talk with you afterwards, son, if you'd like, or staff would. We just don't, that's not kind of how we do it. So, given the criterion, given the discussion that we've had today, the input, recognizing that the road maintenance issue is one of the bigger issues, the biggest issue. It's been suggested that the alternative proposal, the hammerhead proposal, would be a better way to go. Therefore, I too would support the subdivision proposal. Oh, if there's nothing else to be said, then we'll ask Commissioner Shattuck McNally if you want to offer the motion, please.
Sure, Mr. Chair. I move that the Board of County Commissioners approve the Linda Vista subdivision file number 18-LAND 3743, subject to the conditions found in the recommendation above.
Thank you. Does there need to be a reference to allowing that comes later, the findings and resolution? Does that need to be in the motion?
No, the county attorney staff will draft the findings of resolution after this hearing.
Very good. Then that indeed is a proper motion. Any further discussion, colleagues? All those in favor?
Aye.
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 That passes 3-0. I don't believe we have any other business this afternoon. So at 4:31 p.m., we are adjourned.